no longer the time to say IPC, evidence and CrPC. Rather, we should now be saying BNS, BNSS and BSA. So can I say that now this is the time to throw this away, the old criminal manual? So in this video, as a practicing advocate, I want to share with you 10 tips just to understand the kind of impact these 3 new laws can have on an advocate's day-to-day practice. If you already have existing cases, what kind of impact it has on that, and the new clients that you will be getting after these laws are implemented, how do you approach those cases? So let's get into the video. First of all, I would want to give the most practical tip. In any office, the most common practice is to use some templates, drafts or formats to make applications. You take help from your seniors, from your friends, you get the relevant templates for those applications and you understand from them the format and accordingly file your cases. Now it's the time to update all the existing applications and formats that you have with respect to your criminal law cases. I'm about to tell you 3 things, the 3 changes, the most important changes that you have to make to all your existing drafts with respect to the criminal law. First and the most important is of course the section numbers. Everybody knows that once the new act is going to be brought in, the section numbers are going to change. Let's take the example of anticipatory bail application. These bail applications are filed in the high courts and one of the most common type of bail applications filed. Earlier, these bail applications used to be filed under section 438 of CrPC, and now this 438 has become section 482 of BNSS. So your heading in your application is going to change. Now your application will read anticipatory bail application under section 482 of BNSS. Now the earlier section 482 of CrPC was quashing application to High Court. Now that 482 has to change to something else. So this way all the section numbers have to be changed in 2 places. One is in your headings, all the headings of your drafts have to change, and the second is in your content. So while you are making your averments, while you are making your assertions during your affidavits, applications, counter affidavits, you are going to be mentioning a lot of cross and interlinking sections, all of which you will have to be very careful and change them. Then coming to the second type of changes that you have to make to your drafts. The second changes will be with respect to the conditions. What do I mean by this? Again, let's take the example of bails only. Let's take a default bail. These default bails are an option that we used to have under the old CrPC, wherever somebody who is an under trial prisoner who's undergoing imprisonment while the trial is going on, and let's say his maximum imprisonment is for 10 years and he has already finished 5 years in jail. So in those cases, earlier used to file this default bail application and say that, my lords, because my client has already suffered 5 out of 10 years, half the time in jail, please grant default bail. This was in fact the only condition required under default bail. But today in the new BNSS, we have an additional condition imposed. Now not just half the time, not just condition 1, but condition 2 also must be satisfied. So in your affidavits, in your averments, in your counter affidavits, you have to show that the new condition, which is not just one section, in where you have to prove that your client is charged only under one section and not multiple sections. Because if your client is charged under multiple sections, you lose the right of a default bail. So like this, you can say that it's the same, right? Default bail used to exist in CrPC also, default bail exists now also, but yeah, default bail exists. Just changing the section number won't do here. Section number, yes, has changed, but the conditions also have changed. So this is just one of the examples, and if you want to know of more such conditions, definitely watch my other videos that I have made explaining the individual changes that have happened in each of these 3 laws. Okay. Now coming to the third change that you have to make, this is the most important change, is with respect to the filing of evidences. There have been so many changes with respect to Evidence Act and how do you file your evidence, what kind of conditions are imposed on evidences. A lot has changed. I'm going to be discussing other changes in this video itself, so stay with me. And anyway, so my point is, third, with respect to evidence affidavits, you have to make your changes. Okay, so just summing up the 3 changes that you have to make: one is to the section numbers, second with respect to the conditions of the individual applications that you're filing, and third is with respect to how you're filing your evidences. Okay, now moving on, this is the overall thing which is the most practical thing. But now there is a second wing of litigation that's going to start, which is very common irrespective of what law it is. More so if it is a criminal law which has widespread ramifications across the society, you're going to have an increase in the number of constitutional law cases challenging the constitutional validity of various provisions of these 3 laws. So if you're a practicing advocate before the High Court, or if you're a junior lawyer, you're a new lawyer starting out your practice, I would say this is a great opportunity for you to tap in. You will see a rise in litigation, which means you will have more access to cases. And there's also one more perspective. If anybody approaches you, if there's a client approaching you, you can suggest the accused not just from the technicality of what is written in the law, but you can also suggest that they take the approach by going through a writ petition to the High Court, challenging provisions where there is no clarity, or challenging it on the grounds of violation of fundamental rights, violation of principles of natural justice, discrimination. There is a huge scope for you to actually get justice for your clients, not just in the strict sense of the law, but by putting in the constitutional law principles. So I would say that this is a great opportunity for all the young advocates out there. Now this brings me to another point actually. So we are all focused, like I'm sure if you're reading all the newspapers here and there's a lot of chatter on what all has changed, what all is changing. But the most important question to also ask is that what is it that's not going to change with the new laws? As an advocate, from an advocate's perspective, the one thing that's not going to change just because the new laws are implemented is the fact on how you approach the law, how you read the law, how you interact with the law. This is not going to change. Bare Act is always going to be a Bare Act. How you read the Bare Act, how you interlink the provisions of the Bare Act, different sections of the Bare Act, all of this is your skill, and that is going to remain the same for the next 10 years, 50 years, 100 years, how much ever is your practice. You will have so many amendments coming and going, but this ability to interlink all the sections, to read, to understand the reasoning behind these sections, this is the skill that's never going to change, and definitely I would suggest everybody to work on this skill. Now, okay, we have discussed all this, but let's get back to some of the more concrete things. What are the changes, especially with respect to IPC? Sorry, not IPC, now it is BNS. What with respect to BNS that we have to remember? The most important thing, the Constitution of India gives us the fundamental right that penal laws will not have retrospective effect. So any act that is done in the past is not going to be affected by the BNS that comes in. Now in the BNS you must have heard that, for example, sedition is no longer an offense. Okay, that's true. Okay, but what about those investigations that have already started in the past? If there is a trial with respect to sedition that is already in progress, what happens to that? That will still continue, because that is with respect to the old law. The new law will not have impact on that. Similarly, there are some cases, let's say hit and run cases, for example, you can take that. Let's say you have a hit and run case that has happened in 2018, the trial is still going on, and in 2024 you have a law which says, now I have increased the punishment up to 10 years for hit and run cases. But your earlier proceedings, your earlier trial, everything that is already going on, for that you're going to still refer to your old manual only. The punishments given under your old manual will be applicable there. Okay, the new increased punishments will not be applicable to previous acts. This is the most important thing that you have to check whenever you are getting a criminal case in the future. Okay. Now there is another important change that has happened in IPC. So with respect to the amount of fine that can be levied, there have been increases. So whenever again you're getting a new case today, be very careful. You see that under what section are they being charged and what is the fine that's going to be imposed under those cases, because there has been a substantial increase in the amount of fines that can be levied under your different offenses. Okay, this is a little bit of overview about IPC and the things that you have to remember. But according to me, I think the most important thing, you may have the best of the case, you may have the best of the case facts, and you think everything is in your favor. But what is the point if you're unable to prove it? Because it doesn't matter if you know everything unless and until you're able to prove it correctly. Now, how to prove things, what is valid proof, what is not valid proof, all of this, the rules of all of this is what is given under our Evidence Act, which has now become our BSA. Now, in BSA, there are so many changes. Number one, I think there are so many changes, and the changes are so important that it affects our day-to-day fundamental practice. Because, for example, let's say electronic documents. With respect to electronic documents, we have new changes which say that they can be provided as primary evidence. Earlier, they used to be only as secondary evidence. For secondary evidence, there used to be specific conditions, more stringent conditions, and you had to first qualify them. But today, with respect to all electronic communications, which is your emails, WhatsApp, and so many other ways in which we interact with each other electronically, all of that can now be produced as primary evidence, which is a major thing. Similarly, another major change that has happened in Evidence Act is with respect to witness examination. Earlier, you had to bring them to court, cross-examine people, a lot of things were happening. Now we have this that actually also caused a lot of costs and delay. These were the two major things, costs and delays with respect to witnesses, because of which now we have a new provision of teleconferencing or video conferencing and recording of evidences electronically, which is also a great step ahead. So these are all going to affect how what documents you will produce, what documents will be considered as primary, what is secondary. With respect to admissions and confessions, there are so many changes. So that's why I'm emphasizing again and again, Evidence Act is something that's going to have major implications on your day-to-day practice. So for all practicing advocates, this will become a major area to work on. Now moving on, coming to CrPC, which is our BNSS. Now with respect to CrPC, I would say that by looking at it, you may not feel that a lot has changed, because the placement of sections is just a little here and there, slightly a little above, a little below. But if you read the conditions, for example, like I was saying for bail, in the beginning I was giving you examples of bail. It looks like yes, anticipatory bail here, but anticipatory bail conditions, there have been alterations. Default bail conditions have been altered. Police custody, there have been alterations. So just do not look at the placement of the sections for CrPC, which is now the BNSS. Definitely pay closer attention to the conditions that have been imposed in each of the cases, because that is where the meat of the matter lies. So with respect to CrPC, I would say provisions with respect to arrest and all, they look similar, but we will have to definitely read between the fine print. Now CrPC brings me to another interesting point to share with all of you. I really want to emphasize this because the time duration for availing this benefit has now been significantly reduced. So it's important that you know and you do not miss out on this narrow window. Like you are all aware, in criminal law there are some offences for which you can avail, there are some offences in which you can settle the matter, which we call as compounding. For such compounding offences, we had the provision of a plea bargain. However, there was no time limit during which you have to avail the plea bargaining, and mostly accused after 5 or 6 years of trial, when he feels that he is about to lose the case and he can get a better bargain by negotiating or settling the matter, would then opt for the settlements. Now this has caused a lot of wastage in terms of the judicial time, efforts put in, and also the time that should have been allotted to other cases. So in order to reduce these wastages, now we have a new provision which says within 30 days. Mind you, like from 5, 6, 7 years or any time during the trial, we have narrowed it down to a very short period of 30 days, and we are saying that within 30 days from framing of charges, the moment the magistrate frames your charges, within 30 days you have to file for a plea bargaining application if you're interested. Otherwise, you will lose the chance, the option will be lapsed. I think this is another great initiative, so that we do not spend more time or waste any more judicial resources. And another important fact that has come in is the concept of a community service. We have rigorous imprisonment, simple imprisonment, fines, all of this, yes, all these types of punishments are already there. But in case of petty offenses, small thefts, we have this option now where we can opt for community service. This is also going to be a great use for you if whenever your clients are approaching you, you're representing people, and they are being charged for offenses where this kind of an option is available. Definitely it will become a chance for you to plead for community service instead of them being put in jail. For example, any drunken person causing a nuisance, instead of him being put in jail, you have this reformative system where he can be asked to do mandatory community service. Another interesting application is in the cases of defamation. So the law now allows that if you are held guilty for defamation, you can, instead of going to jail, also have the option of option of community service. Of course, it's all in the judge's discretion and the nature of offense, but the fact that we do have this option will give us some sort of a leeway to plead and get some relief for our clients. And anyways, so till now we have gotten an overview of what all these laws are and some important points. But before I end this video, the last point that I really want to emphasize on is the importance of judgments. In our day-to-day practice or discussion with seniors or arguments, case filings, in any of these instances, we realize that the Bare Act is only one small part of it, but a lot of our arguments are developed through judgments. It's through judgments that we plead our cases. So what happens to, whenever there is a new law, what happens to all those earlier judgments? Are they obsolete? No, they don't go waste. They are not, it's not that they are not relevant anymore, because those 50, 60, 100 years of judgments are a summary of the judicial wisdom. The judges have spent their time, they have given us principles of law, they have given us principles on how to interpret during conflicts. So it is this wisdom that's going to be carried on to the new law as well. So today, when you're going to be researching judgments under the new law, if you put the new section numbers, you're not going to find anything. Obviously, you will have to look for similar provisions, the similar section numbers in the old law, understand how they were interpreted, what were the conditions imposed back then, how each provision has changed. So can you apply the judgment even today or not? So this kind of legal reasoning is something you will have to think about. And this is not something new. In fact, when we had the Companies Act of 1956 being replaced by the Companies Act of 2013, or similarly when your earlier excise and customs and service tax regime was replaced by GST, we still refer to all those earlier judgments to understand how the current legislations have to be interpreted. So legal research and all those earlier judgments are still going to be very useful to you as practitioners today of criminal law. I hope in this video you have understood some of the ways in which all these new criminal laws are going to have an impact on your practice. So if you're a new practitioner, you can take these tips to help you get yourself prepared for your criminal law practice. And I hope if you have liked the video, definitely please leave in a comment, share it with all your friends, and definitely do give it a thumbs up. Thank you very much.